The next case to come before the court is Brady Stalnaker versus Anna Stalnaker. You'll have up to 15 minutes to present your argument. Please, well, I guess you don't have to reserve anything for rebuttal because the appellee is not here. Your arguments are being recorded, so please stay behind the podium and keep your voice up. You should not use the name of children or minors or victims. Use general terms or initials. The judges have read your briefs, and we are ready to proceed when you are.
Thank you. There. Keep the culprit quiet.
Understood.
Good morning, and if it pleases the court, I'm going to keep my arguments brief since I did submit a brief on the issues.
And counsel, could you just introduce yourself?
Yes, and for the record, my name is Attorney Susan Latz. I'm here on behalf of the appellant, Anna Stalnaker. And I, of course, reviewed everything this morning, and basically, here's the crux of my client's argument and position. When a trial court is transferring jurisdiction under either 310904D2 or 310906, it needs to make a determination whether that neither parent can be the legal custodian of the child, which is different than saying neither parent is fit to have custody, which implies a physical possessory interest. There's a definite reason for the distinctions in the statutes for that purpose. And that was not done, So, as I pointed out, I respectfully submit it was error to transfer this case to juvenile court. We do respectfully suggest the review is de novo. And again, that the court should have put the language in there that neither parent can be the designated legal custodian. Also, the court was very unclear as to which statute it was referring to. It cites, mentions D2, as that to assume 3109, .04 D2 versus 310906. And then they go on to talk about, in my second argument, I state that the decision to transfer is that we believe that the magistrate did commit an abuse of discretion in her conclusions of law, and also that the findings of fact were against the manifest weight of the evidence. I thought what was interesting here was a lot of this stemmed from a letter that counsel for appellee had suggested by sending to the guardian that the case get transferred to the juvenile court. And it was a suggestion or a query, but it wasn't her recommendation per se. So there was that distinction as well. There was a lot of different reasons cited as to, we argued as to why this wasn't an unsuitable issue, and that physical care of the children was being addressed, their school needs were being addressed, their counseling needs were being addressed. There was no findings by the guardian that the physical structure of either of the homes were not suitable. Mother had taken the children to the supervised visits and had made many efforts with We Care. I specifically recall those efforts because We Care is down in Canton, so it was a bit of a distance for Mother, especially with limited funds and not getting the support that she needed, so it made things a little bit difficult, never mind the fees to take the children to reunify the family, but she agreed and did it. The appointments were an absolute nightmare to get. Getting in touch with anybody there was difficult, and suffice it to say that they ended up, that company disbanding, just couldn't keep it together, so I believe that there were a lot of difficulties there, but that got blamed on Mother, and I don't think that was fair at all. I just think those are some of those logistical nightmares that our clients endure when we ask them, go here, do this, go here, seek this out. We had suggested something closer to her, like that there's a service in Stowe to reconnect children. That would have been much easier, but that didn't get done. Anyway, the rest of it's in my brief. I just came because, if the court has any questions, I'm here happy to answer them.
Counsel, I'm sorry.
Go ahead.
I do have a question.
see, take a look and see. You, under 310906, you have to get consent, and then you have to make those 3 prongs of findings.
But I thought there was specific exception for certain counties.
I'm not aware of any here in my brief. We looked, and I didn't see any, and if that's the case, I apologize, but I did not see any when we wrote this brief for something of that. It certainly didn't come up in our searches and when I wrote this. But it did state that if you want to do that, you have to make 3 specific findings there as to unsuitability, as to can't physically, take care of the kids, housing isn't suitable, you're not fit to have custody, and just look and see what my other one was. Unsuitable for the right to have parental rights and responsibilities for the care of the child, unsuitable to provide the place of residence, and both parents unsuitable to be the legal custodian of the child or children, So that wasn't spelled out either.
I was having some trouble, Attorney Lack, in your brief determining what you were saying specifically the error for Judge Steinhauer was. Of course, this is a magistrate decision, there's an objection that goes to Judge Steinhauer for her decision, which we're appealing. I know you mentioned in here that she, at one point, didn't get 310904 correct. She just said 3109D2. What specifically did Judge Steinhauer do wrong in her?
Well, I think it was
ruling?
making it very clear as to what provision she was going to transfer under.
Okay. Do you think Judge Steinhauer set up the proper standards she had to use on best interest and the care and custody of the children?
I don't think it was crystal clear. That's it.
Any further questions? Okay, thank you for your presentation. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of that decision to you and each party, actually, on the day that it is released. The opinions are also posted on the Ohio Supreme Court website.
Thank you.
Thank you very
Have a
much.
great day.